the next period of contention, that's number 9. What does number 9 go from?
And again, Your Honor, I want to make sure, because I think I want to orient that the list that we're going through now is what the state intends not to play. In section number 9, these are areas in which the defense wants to play. And
can you tell me first what areas you're not contending to play, and then I can ask the defendants, or if you've got those, which areas the defendants want to play.
And just to, from 7:24, approximately 7 minutes and 24 seconds. The third part of that
is about reputation or opinion. This is
or specific acts.
No, it can't come in through specific acts, and I actually have a case to cite today.
But that's to gather the information that they are now putting to the jury that YSL is a criminal street gang. With Detective Gaker over objection, YSL and the people here are, he is the head of or leader of a criminal street gang. So under 403, which is 24-4-403, it's really specious to say, oh, well, he stole from someone, so that's his character. And for of the alleged victim, I'm not using it, or of the victim, the deceased, I'm not using it for any type of, I didn't know, and it's totally speculative. I'm saying that's how the police did their investigation, that the court, through the prosecution, has already poisoned the jury, how the detectives have not done a proper investigation. So that's why I wanted it. What do you think happened? Here it is, and I want the whole flow. That's what I'm saying.
Okay, so let me see if I can get the sum and substance of your argument. Are you saying that particular section of 724.00 to 724.54, that shows another version of the
did this investigation, and it's preposterous because all this is a lie. Everything Mr. Copeland said is a lie, yet they're using him as a primary witness against the Williams and others.
Find this information. I mean, if he's given the police different versions of what may have happened.
When you say what may have happened, because what you're talking about,
what he told them.
But when you say what may have,
my word, to law enforcement about Rich Homie Quan conducting a murder for hire. The state wants to say, well, that's irrelevant because it's a murder for hire of a different person, T-A-Y. My point is, that is the witness. It is a false allegation against another human being to do a murder for hire. The state doesn't get to rely on my constitutional right to have that information, but I don't have it. And this is a prime example that they get garbage. That's my position. Mr. Copeland may say it's absolutely true. The state was going to call Rich Homie Quan. His name's Mr. Lamont.
Because it's not relevant for this issue, whether or not Rich Homie Quan did or did not do the $25,000 for hire. There's no evidence before this court, before this jury, to impeach as to that issue.
But I think they have a good faith basis to ask it.
But they don't.
It would be one thing if they don't know that, but they do. They have a good faith basis to ask it. He's on cross-examination.
But he's not on cross. He's on direct examination right now.
But they're going to get him on cross.
If they get him on cross and they played at that portion, then that's something different. But right now, for the state,
think about it. Okay. Does anybody else have any other objection about this? About this particular segment, which is segment 4, that hasn't been heard as of yet. Mr. App?
Just the Harvey rule, joining Mr. Steele and Mr. Sharp's
okay.
objections.
Mr. Matthews? Mr. Garner? Ms. T. Williams? Leave it fair game. All right, so you will be able to play it. Just have to identify it. But for those
transcripts from this, so I'm going off of my notes. It wasn't clear to me from what was just played, but what I believe what leads into this conversation is Investigator Dennis asking what he knows about not getting people knocked off. And that's what leads into the scooter conversation. Now, we believe that hearsay or otherwise believes that Mr. Thomas has knocked off other people goes to Mr. Copeland's.
There's none.
Well, doesn't Detective Dennis in this particular interview say that, hey, that you might have done it?
No, he does not say that. What you heard him say in that last person is that's what the rumor says. That is what the rumor is, that you did it. And that is what.
First of all,
I wasn't finished.
Okay.
Thank you.
Okay. All right.
MOHAMUD, B State 297, Georgia 532, which is a 2015 case, which was decided after once our new evidence rules came in regarding bad character evidence of the victim. I'm sorry?
Mohammed, do you want the citation repeated? Mohammed versus the say 296.
The Muhammad essentially says that the defendant in a self-defense case has to be aware of the prior, have personal knowledge or be aware of the past violent acts of the victim for it to be admissible in a self-defense case. That has nothing to do with what we're talking about here today. Has absolutely nothing. They want to cite to a case that deals with a completely different area of the law and then base it on, well, because it doesn't fit this, therefore it's not admissible. We're not talking about self-defense. We're not talking about our client of Donovan Thomas's violent propensities.
Let me just talk with you about Mohammed. Mohammed indicates that under 405 that generally it makes a distinction from the evidentiary rule set forth in Chandler before the new evidence code took effect. So they're saying now
Our data works, and it's not the exact time, and obviously it goes by towers. So my understanding of the cell phone records, and I'm sure we're going to hear expert testimony on it, is it's not nearly clear cut like the state says it is. But Mr. Copeland's own statement puts him at the green store. So, which is right there. So, in Your Honor, the other thing is the state can say, oh, well, there's no evidence.
With no evidence that that person killed Donovan Thomas. If they have some case law to say that the law allows that, we would like to see it. But according to 244-405, what they're asking you to do meets none of the exceptions.
Mr. Muhammad versus State of Georgia, and I agree with Mr. Sharp. It's not on point here in this issue. The prosecution keeps saying that there's no evidence that Mr. Copeland killed Mr. Thomas, yet on 4 occasions on the short direct that we had already, the state asked Mr. Copeland whether he killed Mr. Thomas. The jurors don't have to accept his answer. The state has put that ball well in motion. In addition to that, to say that phone records clear Mr. Copeland, phone records are totally going to be in debate, and it's up to the jury. And to say that the state cleared Mr. Copeland and therefore he's not, he's truly not involved in any wrongdoing is preposterous. That's again up to the jury. Mr. Thomas's character is already put in issue. The state did that. They called him the lead.
Reputation or pity, that's first and foremost.
I don't think it's character. I think what they're trying to do is just impeach him. And they're trying to impeach him on the issue of whether or not he has told another falsehood or discrepancy. And they're also trying to bring in fact, from the interview of the police and how they asked him about this particular person.
So, you're right, this would be a collateral issue because, again, whatever happened with this rumor of a killing of someone else is collateral to whether or not Kenneth Copeland or anyone rumors that he has heard in the street based upon the question that they asked him. And looking at Carlson's on impeachment by contradiction, where it says a witness may be impeached by contradiction in several ways. If you call another witness or introduce other extrinsic contradicting evidence, generally speaking, the admission of extrinsic evidence for contradiction and impeachment is restricted to non-collateral matters.
What the guy he is,
Thomas.
Mr. Thomas, about buying haircuts and what kind of guy he is, and he was a great guy, you know. He'd show up and we'd also start smoking marijuana and everyone would be happy. And I don't know if that impressed the jury, but the intent was, he's a great guy. So character has been, that's relevant. Of course that's relevant.
Again, he's saying he does not know if he did it. I think we'd be in the same predicament even if he said, I know this happened, but he said, I don't know what happened. I have no idea. And yet they want to bring in the state of mind of Mr. Copeland.
Okay, let's not talk about state of mind. I think it comes in just for impeachment, okay? State of mind is...
the state has brought in many different videos that they say show Mr. Williams doing certain things, and the response has been, well, he's instructed to do certain things. That doesn't mean that's his true self. And this is another example of Mr. Williams dressing in certain ways, doing certain things. And this isn't me saying this. I'm not the one here drawing connections between wearing a dress and sexuality and all that. Let me just be clear. That's Investigator Dennis doing that. He's saying, well, you're saying he's not gay, he's wearing a dress. And then Mr. Copeland says, well, the reason he does that is for marketing. To get the attention. And so we think that's very relevant, and so we would ask that those parts come in. It's different from Mr. Winfrey, because Mr. Winfrey's not a rapper. Or at least not a well-known rapper. So Mr. Winfrey and Jeffrey Williams, also known as Young Thug, that plays a role in the motive for the